Supreme Court Advocates on Record Association versus Union of India, AIR 1994 SC 868. For the first 20 years, from the commencement of the Constitution of India, Chief Justice of India was appointed following the procedure provided under Article 124. The appointments of judges were made by consulting the Chief Justice of India. The convention of senior most judge of the Supreme Court to be appointed as the Chief Justice of India was followed and respected by the President, that is the executive. But in 1973 and again in 1977, this convention was intentionally disregarded. Attempts were made to neutralize the independence of judiciary by the executive. Finally, the matter came before the Supreme Court, that is, before the judiciary itself. Subscribe the channel and hit the bell to not miss any update. Supreme Court in Union of India versus Consultation said case defined the scope of the word consultation with regard to Article 222. The court held that for an effective consultation, all the constitutional functionaries must be considered, on the basis of which a decision could be taken. Although the court held that the President will have a scope to differ from the Chief Justice of India and even can take a contrary view. The gist of the judgment was that consultation does not mean concurrence. The result of this judgment was that the executive got the upper hand in appointment process of the judiciary. However, the court did not stop there, and again in SP Gupta versus Union of India affirmed the decision of the Consultation said case decision. I have made a detailed video on SP Gupta versus Union of India. Link to that video has been given in the description. Going through that case will help you immensely to understand this second judge's case. By virtue of these two judgments, the judges in the higher judiciary were on total mercy of the executive branch, which has the total power to appoint as well as in removal process. But the second judge's case nullified and overturned the effect of the SP Gupta case, and the system of collegiums was first come into existence. The second judge's case was filed as a writ in the apex court for filling up the vacancies in the higher judiciary. This writ petition brought into reconsideration the controversial judgment of SP Gupta case. Issue. The main issue of this case was the scope of the word consultation in Article 124, Clause 2 of the Constitution of India. In this case, Supreme Court Advocates on Record Association is the petitioner. They argued that Article 50 of the Constitution urges the institutions to separate the executive from the functioning of the judiciary as maximum as possible. Therefore, such upper hand in the appointment procedure vested in the executive is a clear violation of Article 50. Secondly, the upper hand that has been granted by the impugned 1982 decision has made the executive the Lord of the Lords, and this great power has resulted in them becoming overlord. The interference of executive in the matter of judiciary must be minimized. Therefore, Chief Justice of India's recommendation shall not be ignored. Thirdly, this power over the independence of judiciary will result in destruction of a free and fair administration of justice. Fourthly, therefore, to save the basic feature of the independence of judiciary, the court, through its decision, must construe the consultation as equivalent to concurrence. Decision of the court. The bench consists of 9 judges delivered the judgment on October 6, 1993 with 7:2 majority, overruling its earlier decision in SP Gupta, and held that in issues regarding the appointment of judges in higher judiciary, the opinion of Chief Justice of India must be given primacy in order to minimize the executive influence in the judicial functions. Court stated that the largest importance must be given to the recommendation of the Chief Justice of India, formed after taking consideration of the opinion of the two senior-most judges of the Supreme Court. This judgment saved the spirit of Article 50 of the Constitution by minimizing the executive influence in judicial appointments, and thus reduce political influence in appointment procedure. Further, the court also expanded the scope of the word consultation by construing it in equivalent terms with concurrence. The majority judgment was delivered by Justice Burma on behalf of Justice Ray Anand Dayal and Bharucha, while Justice Kuldeep Singh and S.R. Pandian delivered separate but concurring opinion. On the other hand, minority opinion was given by Justice Ahmedi and Justice Punchi, where it was stated that if, as per majority's view, the primacy is to be given to the Chief Justice of India, then, as a result of this upper hand, the role of other constitutional functionaries relevant in appointment procedure would become minimal and negligible. This erosion of power will result in an injury to the basic aspect of the Constitution, that is, separation of power, and ultimately this power given upon the judiciary will often result in biasness, conflict, and finally to chaos. The majority, along with delivering this landmark judgment, also provided guidelines which must be followed in future in the procedure of appointment of judges in higher judiciary. The majority bench provided that in case there is a need of appointment of judge of apex court, the initiation of proposal has to be from the Chief Justice of India, and in matters of high courts, the proposal must be from Chief Justice of the respective high court. Likewise, in transfer of judges of high courts, initial proposal must move from Chief Justice of the High Court, and in case of transfer of Chief Justice of the High Court, initial proposal must move from the Chief Justice of India. Court affirmed that no appointment shall be made unless it is in conformity with the opinion of Chief Justice of India. For the appointment of Chief Justice of India, the senior-most judge of the apex court must be appointed as the next Chief Justice of India. The guidelines framed by the court are as follows. The Chief Justice of India must be given primacy, but he must consult with his two senior-most colleagues. All the constitutional functionaries involved in the appointment process must participate harmoniously. Transfer of judges cannot be challenged in the courts. The court thus held that in the choice of a candidate suitable for appointment, the opinion of the Chief Justice of India should have the greatest weight, as he is best suited to know the worth of the appointee. The selection should be made as a result of a participatory consultative process in which the executive has the power to act as a mere check on the exercise of power by the Chief Justice of India to achieve the constitutional purpose. Thus, the executive element in the appointment process is reduced to the minimum, and any political influence is eliminated. It has been categorically declared by the Supreme Court in the second judge's case that the process of appointment of judges has to be a participatory consultative process. The intention of our constitution makers was such that the executive and the judiciary both will be involved in the process of judges' appointment. However, the majority judgment of the second judge's case stated that if in any case of conflict between the opinion of the collegium and the executive, discussion should be made to come to a unanimous decision, or as a healthy convention, the recommendation made by the collegium will have primacy and the executive will be bound to appoint the person. However, if there be any disagreement, even then between them, which cannot be solved by joint effort, the question of primacy would arise to avoid the disagreement. Even though no appointment can be made unless it is in conformity with the opinion of the Chief Justice of India, yet in an exceptional case where the facts justify, anyone recommended by the Chief Justice of India, if considered unsuitable on the basis of positive material available on record and placed before the Chief Justice of India, then that person may not be appointed. But if the person recommended by the Chief Justice of India is not appointed, then the reason for his being unsuitable for the post should be disclosed to the Chief Justice of India, so that Chief Justice of India may reconsider and withdraw his recommendation already provided. The issue of seniority. Seniority is certainly a factor upon which the appointment of judges takes place. However, the court clarified the debate regarding seniority by presenting the concept of legitimate expectation. It stated that a senior judge has a legitimate expectation to be elevated as a Supreme Court judge. However, those judges who are meritorious also have a legitimate expectation to be elevated. The court held that unless there be any strong cogent reason to justify a departure, that order of seniority must be maintained between them while making their appointment to the Supreme Court. Hence, in the second judge's case, the court categorically stated that the person to be appointed shall be the best and suitable for the prestigious position of the judge. Hence, seniority will play its role, but not at the cost of merit. The court also held that judicial review in the case of an appointment or a recommended appointment to the Supreme Court or a High Court is available if the recommendation concerned is not a decision of the Chief Justice of India and Collegium, which is constitutionally requisite. The obligation of the Chief Justice of India in appointment procedure. The first and foremost obligation of the Chief Justice of India is to make such a recommendation to the executive who is acceptable to it as the best and suitable choice. This obligation exists on the shoulder of the Chief Justice, since the proposal of making an appointment has to be moved by the Chief Justice. The recommendation shall be made in written, and all the just and cogent reasons for the recommendation must be laid along with the views of other judges. Thank you so much for giving me your valuable time. I hope you liked the video. If you have any doubts, do let me know and I'll try in the best possible way to clear those doubts. Subscribe the channel and hit the bell, as I'll be posting regularly such law contents. Till then, I'm Ricky, signing off.